Welcome to the Chapter 2 video lecture. Chapter 2 focuses on all the constitutional limits on criminal law. The first limit we're going to talk about is the principle of legality. This is can be summarized fairly clearly in that no crime without law, no punishment without law. We should not be criminalizing or punishing people without the background of the law. Now, there are three underlying constitutional principles that support the principle of legality. But the principle of legality is the first and most important premise of constitutional law. Now, the first underlying supporting principle is the ban on ex post facto laws. This is in Article 1 of the Constitution, and it says that we cannot, an ex post facto law is unconstitutional, and ex post facto laws either criminalize an action after someone has done it, increase the punishment after someone has done the behavior, or take away a defense after someone has engaged in the behavior. Each one of those three things violates the idea of no crime without law, no punishment without law. And we ban ex post facto laws to prevent arbitrary and vindictive laws and protect citizens. So this is of benefit to the people. So again, though, criminalize after the fact, increase punishment, or take away defense after. Now, the second supporting principle is the void for vagueness doctrine. Void for vagueness has kind of two primary purposes. They make sure that we are all given a fair warning of the kinds of behavior that are criminal, and they reduce arbitrary and discriminatory law enforcement behavior. The principle here is that when a government writes a law that is vague, it violates our Fifth Amendment protections against due process, as well as our 14th Amendment protections. So we need to know what behavior we can and cannot engage in. We need to be able to clearly find the law and read through it to know that we cannot do this or that. So your book has a fantastic example of this. It's State v. Metzger. Metzger was convicted of violating a city ordinance that prohibited indecent, immodest, or filthy behavior. This was in Nebraska. Metzger lived in an apartment. He was on the ground level of his apartment complex, and he had a window where you could walk by and see into his home. He was somebody parked in a parking spot in front of his apartment. They looked through his window, and he's standing there naked, eating cereal. And they could see his body from the mid-thigh up. So somebody called the police on him, and then he was charged with violating this ordinance, which prohibited indecent, immodest, or filthy acts in the presence of another person, or in a situation that persons passing might inordinately see the same. The question is, what do those words mean? Is it immodest or indecent or filthy to be inside your house eating your cereal naked? For some of us, yes. For others of us, though, a previous semester I had a student say, well, I think he's just living his best life. So I don't see anything wrong with it. So, there are different takes on this behavior. And the thing is those three words have different meanings to different people. Therefore, they're vague. If they wanted to criminalize this, maybe they could be more explicit, such as being nude in a situation where others can see you, or those who pass by may observe your nudity, is a violation. So that's a lot more clear. We know that if we eat our cereal in front of a window while we're naked, that we would violate that because it explicitly tells us that you cannot be nude in front of your window. So we need to know that. We need to know what the law is actually prohibiting. All right, the last underlying principle for the rule of lenity is the principle of legality. And this is the rule. The rule of lenity says that courts should resolve all ambiguities in favor of the defendant. This is because the prosecutor has the backing and the power of the state, and the defendant does not. Therefore, if there is an ambiguity in the law, it should be decided to the benefit of the person with less power. But over time, this rule has been narrowed. Most states follow what is called the narrow lenity rule, which requires these ambiguities to be resolved in favor of the defendant only for more serious felonies or the core felonies. So that is the rule of lenity. Now, we need to talk about proving guilt in criminal cases now. Every criminal case the prosecutor needs to, the defendant starts with the presumption of innocence. We presume you are innocent until you're proven guilty, right? We kind of all are aware of this going on. So the prosecutor has the burden of proving each and every element of the crime beyond a reasonable doubt. If they can't prove all the elements to that standard, then the defendant cannot be convicted of the underlying offense. So the duty is on the prosecutor to prove beyond a reasonable doubt. So that's what you need to know about proving the guilt. It's the duty of the prosecutor. Now, if the defendant has a criminal defense, which we are going to talk about after the first exam, these are things like insanity, consent, duress, entrapment, self-defense. If the defendant has a criminal defense, there are two types, a justification or an excuse. They both work the same way. The defendant admits to the underlying behavior. They say, yes, I committed this homicide, but my behavior is justified because of my defense, or my behavior should be excused because of my defense. My behavior should be excused because I meet the legal standard for insanity. So if the defendant presents one of these types of defenses, any of the justifications or any of the excuses, then the defendant has to put some evidence in support of their affirmative defense into the case. They need to tell us some reason to explain why they believe this to be self-defense, why they think duress happened, why there was a consent to engage in the behavior that negates their criminal liability. So defendants have to produce something to show that they're insane, that self-defense applies, that any of these defenses apply. The defendant to successfully use a criminal defense they are held to a lesser standard. They are held to preponderance of the evidence. So a defendant establishes insanity to a preponderance of the evidence. If we think back to last week's video lecture and last week's material, 50% plus a feather. So it's a lesser standard because they have less resources and access to than the state. That is really important to know moving forward, because next we're going to shift and talk about the Bill of Rights and the limits that the Bill of Rights places on criminal law. All right, so the First Amendment, the first amendment in the Bill of Rights gives us the freedom of speech. Now, you do not have freedom of speech to other citizens. Like, you don't have the freedom of speech against your parents or your guardians. You can't tell me not to use swear words because you're violating my freedom of speech. Freedom of speech is where the government limits what we can say. unless, and it protects expressive conduct, like flipping the bird or wearing a black armband or burning items in protest of an event like the American flag. So all of those things are freedom of speech. And this applies to the states, and there's 5 exceptions to freedom of speech. There's no freedom of speech for obscenity, which is appealing to prurient interests over kind of just pure sexualization. If it has an artistic element, though, it's not obscene. Profanity, irreverence towards sacred things, libel or slander, which are damage to somebody's reputation, fighting words, which are words that would provoke an average person to retaliate, or clear and present danger. So if you engage in speech that evokes a clear and present danger, that can be limited. Otherwise, though, the government cannot tell us kind of what to say. Your book has an example of a statute that was thrown out because it was overbroad when it was trying to regulate cyber harassment, and it was just too broad, so it violated the First Amendment. One other thing to note, one thing that's going to come up towards the end of the semester when we talk about moral order crimes, is the government cannot tell us what to say, but they can limit the time, place, and manner of the speech. So they can say that you have to have a permit to protest, or you can only protest in a certain area. But they can't say only certain groups can do this. We're only going to give the Jewish organization the ability to do this, but we're not going to let a Christian organization. So they can't regulate the content, but they can tell us like times, places, and manners. Now, the next amendment to talk about is the Second Amendment. Second Amendment has not really been litigated as thoroughly as most of the other amendments. In 2008, we see DC versus Heller being decided, which makes it a individual right instead of a state right to bear arms. And then we see McDonald versus Chicago, which made it also the right state right. Now, states and federal government can still limit those who can purchase. They can say that those who are felons do not have a right. Those who are have certain mental illnesses don't have a right. Those are still valid. But there isn't individual rights. There can be no like outright restriction on the ability to own handguns and things. It is constitutional to ban certain types of weapons. We saw that within multiple years ago. There was a ban on assault rifles. That isn't constitutional, but there cannot be an outright ban on all types of firearms. All right, now the next part of that your book talks about is the right to privacy. So privacy is not explicitly in the Bill of Rights, but it is based on the principles of the 1st, 3rd, 4th, 9th, 5th, and 14th Amendments, all of which give us some right to privacy on our persons, our papers in our homes, which require us to have due process, which requires that we cannot be forced to quarter troops, things like this. So we have this kind of inherent right, especially in our houses. And if you think back, if you've watched the, no, actually we won't go there yet. But so it's based on multiple different rights. This is a great little chart again that kind of explains some of these cases and what they stand for. We see contraceptives, consensual same-sex intercourse. All of these things have been found to violate a person's right to privacy against the government. The next part of the book that is dealt with here is the 8th Amendment, which prohibits cruel and unusual punishment. And this has been deemed to mean barbaric punishment. So things that are cruel and unusual are barbaric. These are things that are no longer considered acceptable by a civilized society, and those things have evolved over time. So original punishments like hanging somebody or drawing and quartering them at one time were acceptable and did not violate the Eighth Amendment, as other methods of execution have been established. What is acceptable has changed as far as a cruel and unusual punishment. This does apply to more than just capital punishment, though. It does include things like fines. Like a fine can become cruel and unusual if it's extremely excessive. And your book does a great job of kind of working through this. It also notes that one part of what's cruel and unusual is that the punishment should fit the crime. And so if we should not have capital punishment for a misdemeanor or even for a felony that doesn't severely harm society. So the principle of proportionality is extremely important to accurately understanding the Eighth Amendment. Punishment has to fit the crime. And one aspect of that the proportionality, this decision that we're going to talk about, these decisions are going to are rooted in proportionality, is the idea that death is different. So proportionality applies to all death penalty cases, and as a result, we have seen groups be excluded from capital punishment. For example, we cannot execute a juvenile for a crime they committed. That is disproportionate to the harm caused. This is outdated terminology. It should say intellectual disability here. This is a specific condition that's diagnosed using the DSM, which it has to be diagnosed during childhood. You have to be 2 standard deviations below the average IQ, and you have to struggle with adaptive tasks, meaning it's hard for you to maybe hold a job. You can't maybe tell time or drive yourself or things like that. That you struggle to do the day-to-day aspects of living in society. So this does not include like all mental illnesses or anything like that. Since this book has been published, the Supreme Court has also said that those who are incompetent are excluded. There are 2 ways that a defendant can become incompetent. One is that they are insane. We cannot execute an insane defendant, as well as a defendant who does not understand that they are going to die cannot be executed. So this can come about through Alzheimer's or a health condition that deteriorates the mind. And that case was just decided about a year ago. Another group that is excluded from capital punishment are rapists. Only first-degree murderers are eligible to receive capital punishment, not second degree, not rape, not kidnapping, not any of these other offenses. Because death, this is the idea that death is different. And your book contains the excerpt from 2008 Kennedy versus Louisiana, which determined that the death penalty is cruel and unusual for the rape of a child. Continuing on with proportionality, a juvenile cannot be sentenced to life in prison without parole. We have to leave open the fact that a juvenile will mature and grow, and that they may, we cannot say, no, you're going to spend the rest of your life in prison. Now, 3 strikes in your outlaws are constitutional. So we can severely increase the punishment if you have been convicted of multiple felonies. And mandatory minimum sentences are also constitutional. Now, some other constitutional rights that we need to talk about are the right to trial by jury. You have the right to trial by jury for any case where you may face prison time. We do have advisory sentencing guidelines after 2005. So the judge will look at the sentencing guidelines, determine the range, but they can decide to go above the range or below the range. The literature here, the research here shows that judges do not go above very often, only about 2% of the time each year. They do go under, but they do have to provide reasons for why less punishment is required here. And an example of that happened in Gall versus United States in 2007, where Gall had completely rehabilitated his life, started a business, joined the church, got married. But while he was in college, he sold ecstasy as part of a ring. Later, the FBI was investigating. He was sentenced to prison time, or the judge departed and sentenced him only to probation. And that was challenged because the judge departed from the guidelines significantly. He should have served time in prison. And the Supreme Court said that was okay based on his individualized circumstances and what had occurred in the intervening time. Probation was reasonable based on the individualized assessment of the defendant. So judges can depart, but they do have to explain to us why. All right, so this concludes the video lecture here. I would make sure that you kind of focus in and you kind of have a basic idea of the first, the second, the fourth, fifth, and sixth, and eighth amendments for this chapter. Those are the big ones that impact criminal law and the criminal justice system. As well as understand, it's really important to understand the principle of legality and those three underlying principles. So if you have any questions about any of the concepts or material, feel free to reach out and I will see you next week.